Deven McGraw is a partner at the healthcare practice of Manat Phelps. She specializes in privacy law and HIPAA matters. She's been at the Center for Democracy and Technology, and she's one of the people who has been assisting the Patient Council in trying to determine the privacy rights issues that we're going to be grappling with. So I really appreciate having you here, Deven.
All right, so what I'm going to talk to you about today is HIPAA, everyone's either least favorite or favorite topic. It happens to be a favorite of mine. I'm probably the only one in the room who would ever say that. Yay, I got one more. For those of you who don't know what HIPAA is, it actually doesn't, it stands for something that doesn't have the word privacy in it at all. It's the Health Insurance Portability and Accountability Act. But it was a very small provision in HIPAA that directed HHS to come up with privacy rules. And HIPAA, and it now really stands for, in the minds of a lot of people, the privacy and security rules that govern health data. And they govern health data when it's held by pharmacies, when it's held by laboratories, when it's held by doctors and hospitals and health plans, but it's not a data protection law. It doesn't cover the data in your app, for example, if you're uploading health data into a mobile application. It has very sort of confined parameters of coverage, but for purposes of sort of evidence-based medicine, HIPAA sources of data are a really critical source of data for moving that forward. So it tends to be a really important set of rules. And so just some general provisions around how HIPAA governs analytic uses of data. When you de-identify the data, it's not considered to be protected health information, which is the term of art, defined term in HIPAA for what gets regulated. It's not PHI, and it's not subject to HIPAA at all. We're not going to spend a lot of time in this talk talking about de-identification because that, in fact, could eat up all of the time. A limited data set, which is less identifiable but still considered to be at greater risk of re-identification, and so it's still regulated by HIPAA, although less so because it has less risk. Names and addresses and things of that nature are stripped out of it. There is pretty heavy reliance on those two models because the regulatory constraints either fall away completely or are lessened, but they're not always ideal for all types of analytics. And just to give you an example, in de-identified data, for example, you have to strip out dates. And dates are often very important for research questions. And so, leaving the dates in sort of requires you to either de-identify through statistical methodologies, which a lot of entities are not that comfortable using, or you can go to a limited data set, but ultimately, having more identifiers in data sometimes is just what you need to answer the query, and fully identifiable data or data that doesn't meet these criteria is pretty significantly regulated, as you would expect from a privacy standpoint. So under HIPAA, you need consent if you are going to use someone's data for research purposes, unless that consent is waived by either an institutional review board or an entity called a privacy board, which is an alternative to an IRB. I don't hear of too many people using privacy boards. Most people use IRBs. The common rule, which are the rules that govern federally funded research, also requires consent for research using identifiable information. But it also includes a waiver provision. And the conditions for waiver in both laws are not exactly the same, but they're fairly similar. And they largely involve a balance of the risks and the benefits. Could the research go forward if you had to go ask people for consent? And what are the risks to people of not asking for consent? And do you have some other protections in place, for example? And it's really a determination that gets made by an IRB. And on some level, this is exactly where that determination should be, right? Who's going to weigh, who isn't so ingrained in the research that they can't objectively think about weighing the risks and the benefits. But ultimately, what often happens is that IRBs with different risk tolerances will come down very differently on the same question. And when you're trying to do research across multiple institutions, this can quite frequently be an obstacle and sometimes an insurmountable one. So as I said, you need consent to do research under HIPAA. And actually what you really need is authorization, which historically was always study specific. This particular study, which meant every time you wanted to use that data for a research project, you needed to, unless you got that authorization waived, you needed to go back to the patient and get them to sort of fully understand what you were doing and get their authorization. There was a change in guidance to that regulation that took place in January 2013, where the agency that has oversight over HIPAA, which is the Office of Civil Rights in HHS, said, you can actually get more general authorizations for future research. It doesn't necessarily have to be study specific, as long as you describe that future research sufficiently that somebody would, down the road, who found out that their research was, their data was used for that reason, wouldn't be totally surprised. Well, what does that mean? Can you say any research for breast cancer treatment and prevention? Is that sufficiently described? Can you say any research done by Mount Sinai? Is that sufficiently described? There is no other guidance beyond that, and I haven't really heard of very many institutions feeling comfortable with sort of dipping their toe into that water and testing those boundaries. So it's not really clear just how useful that change has been. HIPAA, if you are using a patient's data for treatment or to get paid for care or to process payment if you're on the health plan side, or for a list of activities that are considered to be healthcare operations, which generally are administrative and operational tasks associated with the business of being in healthcare. And when you're using data for, or even sharing data for one of those reasons, you do not need the patient's consent before you either use or disclose data for those purposes. And the reason for structuring the rule in that way was to say, look, a medical record is a business record of an institution or a healthcare practice or a health plan, and there are certain things that they're going to need to do with that data to be a healthcare business, and they shouldn't have to ask the patient's consent. They can if they want to, but they shouldn't have to ask the patient's consent to use data for that purpose. Now, states are allowed to regulate on top of HIPAA, and some states do have consent laws even for treatment uses and operations uses, but HIPAA does not. And operations, interestingly, includes conducting quality assessment and improvement activities, including outcomes evaluation and the development of clinical guidelines, as long as obtaining generalizable knowledge is not the primary purpose of any studies that result from those activities. Operations also includes population-based activities related to improving health or reducing healthcare costs and protocol development. Again, as long as the primary purpose is not contributing to generalizable knowledge, you're in operations. If you're contributing to generalizable knowledge, you're in research. And similarly, the common rule says research is a systematic investigation that is designed to develop or contribute to generalizable knowledge. So the way that this typically gets interpreted is, if we're just going to use what we learn for ourselves, our own institution, our own integrated delivery system, we can consider it to be operations. But if we share what we learn with the outside world, then it's research. So that to me creates a paradox. Two studies using data for quality improvement, both use the same data points, done to address the same question or set of questions, and done by the same institution will be operations if they're only going to use it internally, research if the primary purpose is to share the results with others so that learning may occur, and guidance on what's meant by what is the primary purpose allows for a later change in plans, like, you never intended to share this, but whoa, what did we learn? This really, somebody needs to find out about this. Then you're not in violation of the rules if you publish what you learn or share the results with others. But if all along you think you might be onto something that might be shareable, well, no, you're in research all along. So it's a very confusing, not only is it confusing to manage, it is also not advancing the learning healthcare system to draw the line between what you do with the results of what you learn. It doesn't really speak to whether you release the data. You don't have to release the data as long as you're intending to share what you learn, you're in research. So to me, this is really, in many ways, creates disincentives for sharing and forces people into sort of the path of least resistance bucket from a regulatory standpoint, which is we need to consider this operations so we don't have to go through consent. And when I'm on the Health IT Policy Committee, which is a federal advisory board, we took a look at this and basically, with lots of heads around the table, including me when I still had a consumer hat on my head, we said this was ridiculous. Look, if you're using data in a way that doesn't create privacy risks and you intend to share the results, but the actual use of that data is controlled by the institution, under oversight. Why would we need to treat it as research just because you're sharing the results? And we need to find another place to draw the line in terms of where we would regulate more stringently. So if, in fact, HIPAA is, because of this, getting in the way of some research initiatives or creating these really odd disincentives with respect to how you conduct any sort of quality improvement or population-based activity involving really a reuse of data. So this is data that has mostly already been collected as part of a clinical encounter, or if it's on the health plan side, was collected for payment purposes. So really, what you're talking about is what are the circumstances under which you can go back and look at it again, right? Certainly if there are interventional risks and you're talking about a clinical trial, first of all, that more than likely kicks you into the common rule, and there would absolutely need to be a different set of circumstances to consider that, depending on what the risk of the intervention is. But what are the risks associated with just the reuse of that data? And why can't HIPAA regulate based on risk? It seems like it started to go down that pathway, but it probably got this one not quite right. So can we modify the regulations? Well, yes, of course we can, in theory, but that's a really hard thing to do, especially when HHS just changed their HIPAA rules and they don't probably have much of an appetite for going back in. So is it possible to get guidance out there to say, for example, to IRBs in terms of conditions of waiver? Absolutely. It's something that I know that I have talked to the Office for Civil Rights about. I don't know, you can never tell exactly whether they think this is a worthwhile thing to do, but it's, this sort of continuing drumbeat of needing to have a regulatory framework that both protects patients from risk, but also advances what is very important to patients, which is learning more about what's going on in healthcare. I think that we ought to have programs like we have in Medicaid that waive the requirements and test different frameworks for how we both advance research and accommodate, while also doing so in a trustworthy way, right? Because privacy and confidentiality protections, in my view, are really about how do you create a trusted ecosystem here so that data is being used responsibly and there are checks and balances on the process, and how can we build that in? And by the way, how can we involve patients more in this? In research, we tend to think that if we've gotten their consent, we've pretty much involved them in the research. But are there ways that we can really reach out to patient communities and involve them in the types of research that we do, in giving data back to them, so that they have it in their possession and can do with it, use it in ways that are important to them? What other mechanisms of accountability can we test and then find out how well they work in terms of building trust and patient comfort, as well as advancing research goals? We just don't do that. We just assume that these rules that we created, a decade or more ago, fit with the environment that we're trying to create today. We also don't have any incentives to pursue what I call privacy protecting architectures. So Lorraine mentioned PCORnet. We're trying to structure PCORnet, which is 29 different research initiatives, in a way that the patient identifiable data remains with the organization that collects it or stewards it, maintains it, and the analysis goes on locally, and the results are shared collectively. You need a common data model so that you can be drawing comparisons across similar data in different institutions, but you don't have to release the patient raw data and create, sort of one single centralized database necessarily for all your research queries. It's a distributed network, essentially. You don't get any credit for that in HIPAA. There's no it's only if your IRB recognizes a distributed network as being potentially more protective and therefore incorporates that in the calculation of risk in terms of granting a waiver. But there aren't really any sort of incentives to sort of think about, to give people reasons to think about how do we structure the research enterprise in a way that creates the most amount of protection for patients that we can conceive of while still making sure that the research gets advanced. And so that, I think, is the end of my talk. But I look forward to the discussion with my fellow presenters and with you. Thank you.